Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
Let's go.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, here we go. How is everybody? Happy Thanksgiving. I wanted to get on here and start a little early today. My apologies about the sound yesterday. I didn't realize how low it was. For court, I've adjusted it for today. So I thought we're going to go through today's Karen Reed hearing. They are picking out, asking for certain pieces of evidence to potentially use in Karen Reed's trial. The prosecution is asking for certain pieces of evidence, and the defense is staving it off and saying, no way. This was a pretty exciting hearing for me to watch. Hank Brennan, who is the specially appointed prosecutor in this case, he is on a team now with Adam Lally. He's looking very sharp, really hard to criticize anything that he did in court yesterday, on top of his game, and we'll see. He's asking for a lot of things that we didn't see first time around. Karen Reed's father's phone records, Karen Reed's mother's phone records, also asking for the entirety, which was asked for last time, but unedited interviews from Boston Magazine writer Gretchen Voss, and basically all the unedited interviews that Karen Reed has given since the beginning of this case. And I think what they will find is that they're very contradictory and not helpful at all, which is why most lawyers tell their client to zip the lip, keep quiet. Silence is golden. We're going to go back a little bit in the hearing from where we left off yesterday, just to give it a little context. So we're going to pick up where Hank Brennan is asking for Gretchen Voss's unedited tapes from her interview, so for her Boston Magazine article. And there was, of course, heavy redactions in those tapes. So he's asking for the unredacted tapes, including her lawyer. So she gave interviews with Yannetti and Jackson there. And he wants to hear everything that everyone said in these interviews, including Yannetti and Jackson. So should be pretty interesting if the Commonwealth gets that. Are we going to hear Yannetti and Jackson saying like, hey, wait, don't say that, interrupting Karen at crucial times? But as is the redactions, there's 150 redactions approximately in total in both tapes. And the second tape may be an hour. The defense says it's an hour. The Commonwealth says it's 2 hours. And what was handed over was 19 minutes. So that's a heavy, heavy redaction, whether it's an hour or 2 hours, 19 minutes out of an hour, 19 minutes out of 2 hours. It's still more redactions than not. So let's get into it. This is yesterday's hearing. Article 17 hearing, I believe it's called, for Karen Reed.
The Commonwealth has filed a motion to reconsider in part, and in addition, there is a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, they were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both.
So interesting. So it sounds like over 90 interruptions by her lawyers, either by Attorney Little, by Attorney Yannetti, or Attorney Jackson in that interview. So they're stopping Karen Reed from going forward, from saying more, or they could be giving context. But if you saw the opening, which I play every time now because I love it so much, such a good example of when asked directly how someone does not want to lie because it's stressful lying. So she, instead of saying, no, I didn't do it, she says, we all know who did it. And so Attorney Jackson has to bust in there and say, no, she didn't do it. No, she didn't do it. She asked a question, which is very different. I love that one guy. Why'd she admit to it? Why'd she admit to it? She didn't admit to anything. She asked a question. Like it was only one time. It was a series of admissions. I hit him. This is my fault. Is he dead? Seemingly, I think, I'm really interested in doing an episode about all the things Karen Reed knew before anyone else. that an innocent person just couldn't know. All the things she was asking questions about, throwing out as either as speculation or as fact beforehand. Psychic Karen Reed. So back to Brennan. He's asking for Gretchen Voss's unedited audio tapes in her interview with Karen Reed. I assume there are audio tapes and not videotapes, not some other kind of audio tapes. I'm so old. Digitally recorded audio.
Both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of the defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all 3 of the attorneys are witnesses as well. Now, the Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those, the strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on two propositions. Number one, Commonwealth versus Doe, promulgation, those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it, she said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced, because there is none. The cases are dissimilar, because they deal with trying to get to a confidential source that may expose a source that never even may not be used at trial anyways, because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so,
what a risky game. What a risky game she played. So when you're weighing the risk versus reward of giving an interview, you're weighing the potential of anything you have said in this interview being used as evidence against you. Not surprised that all her lawyers were in tow for that interview, but I'm curious to know if they were at every interview. Because by the looks of that courthouse step interview, she's not the best. She always likes to say what happened. Basically, she's not a very good spokesperson for herself. Alan Jackson has to step in and say, no, she didn't do it. Karen Reed can't say, no, I didn't do it for myself. And Alan Jackson has to step in for her. That's just one of many examples. I've heard in the comment section, people are saying, look, I thought she could be innocent up until now, up until when she just gave these new interviews that she just did. So she just can't stop talking, because for Karen Reed, the innocence fraud campaign is all she has. Think back to her trial. Think back to that Bang Bang video and trying to make Callan Albert look like public enemy number one. It was one of the dumbest things I've ever seen, and most desperate, dumbest and most desperate things I've ever seen a defense team do at trial. Was that Bang Bang, Colin Albert and his friends taunting a fellow rival sports team as proof that he somehow really was the real killer in this case. I thought it was absurd. May have played well with the free Karen readers, I don't know. But for me, I thought it was absurd. So think back to their experts, think back to Lucky Loughran, their star witness, was confused, eyesight problems, seemed to be repeating a narrative told to him by Yannetti. You met with him in the parking lot. It was very weird. The school of a witness, a child of a witness, it was odd. Why meet there? But okay. right before Lucky Loughran testified, but then think to the dog bite expert. Terrible. Could barely spit out the lines. She was almost thrown out as an expert in that trial. Cannoni just let her in, I think, just because she thought that maybe she could have gotten overturned on those grounds because she had so few witnesses, Karen Reed, for her. The Commonwealth's case took 8 weeks, something like that. And the defense's case wrapped up in a matter of days.
So, since it is not a confidential informant, it's a very public, identified person, it's Miss Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I have never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in a case. And my empathy is to Ms. Voss, but to every other witness in this case. She is in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case. It just doesn't. And so there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it, and we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. And the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Mr. Birch.
So my point was that Karen Reed weighed out those statements being used against her, and she decided that the better thing to do was to speak out and to increase the strength of her innocence fraud pretrial campaign. Rather, it was worth the risk of those statements, of having contradicting statements. And it was a safe bet in the first case. None of this came in the first trial. First trial, excuse me. None of it came in. It was a safe bet. But this time, I think some of this has to be coming in. People forget that my point was yesterday that what we're watching is a evidentiary hearing, but at trial, Karen Reed's own statements can be very damning. We like to think of evidence as physical evidence, especially DNA evidence, but testimony, they play tapes of Karen Reed talking at trial. It's contradicting herself. It's going to be very bad because there's only one truth. So when you're telling 15 different stories, and Karen Reed loves to lie, she's been caught in so many, she looks guilty. All her credibility is gone.
Thank you, Your Honor. Robert Birchie for Metro Court and Gretchen Voss. I've been here before, Your Honor, on a remarkably similar motion. And Your Honor at that time made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth...
Right, but Brennan's point was like, it may be off the record, but there's no such thing as off the record when it comes to evidence. Off the record means it wouldn't be printed, but there's no off the record here. She had to know this could possibly come in as evidence. Curious to see which way Cannoni goes on this, but you can see the camera freezes on Karen Reed here, and these kind of lawyers she picked, she's very image conscious, and this elderly man, she seems to really, like, I don't know, seems to find just the fact that he seems to have trouble hearing and not, the high-powered statusy lawyer, because status and image is everything to her that she's used to, that he's not in that vein. She seems to really find distasteful just by the look on her face. Let me know what you think. Hey, Dean Walker, happy Thanksgiving. I saw in the comments you're making a roast. Sounds delicious. Enjoy your pre-Thanksgiving. I am catching a train as soon as this finishes up. So I do have I'm going to stop at 7, definitely tonight.
Has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back, even at the first trial, to come back and request it upon review of the first release?
I'm sorry, I didn't quite...
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
Okay, go ahead.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial.
Well, you're looking at all her statements across all her interviews and seeing how they all contradict. So if I love that he says he can't see the significance of Karen Reed in a more relaxed environment than court contradict herself. I mean, come on. Come on. He's a lawyer. He knows the significance of it. And if she testifies, can ask her about it. So.
And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article, and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family. And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. You said it was a close call, but given making the division, what I call the Solomonic division of providing some and limiting others, seemed to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corporation's counsel undertook time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss of a one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are they're phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview, if forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her or call her a trial in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case. That this already had so many. It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial. Because if she is called to witness, she is not permitted to sit in the courtroom for the proceedings.
So she did attend the last trial, right?
She did, because
on a
she
daily
was not
basis.
on a witness list.
Right, on a daily basis.
I believe so, yes.
Okay.
Every day? Yes.
Okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry.
That was Ms. Voss who just responded to you, yes, correct?
Yes.
Okay, thank you.
Yeah, it seemed like he didn't even catch what she said. And he was just saying yes, because he didn't want her to repeat it again. Was that Gretchen Voss, who said she was there every day at trial? But I'm shocked that Cannoni said that Gretchen Voss didn't have to hand over her off-the-record recollections or notes from her off-the-record conversation with Karen Reed, because it would ruin her reputation with sources to keep things private and off the record. But it's very different when you have a source and you're saying, I'm not going to print it, but now you have the accused giving an interview. She had to know, with all her lawyers, that anything could come in off the record or on the record. And as far as Cannoni, what I'm more shocked at is that witness harassment became a real issue for Cannoni to say no here too, because every witness could be potentially harassed, and many were. So everybody had to deal with that in this case, and that was Karen Reed's. It worked. Boy, it was helpful to Karen Reed to harass witnesses, to keep them out of the courtroom. Basically, you're capitulating to the defense team there. I mean, if they want to have some kind of security, I mean, I don't know. I can't even imagine how much this is costing the Commonwealth second time around. These trials are expensive.
And finally, the Commonwealth asks for the first time, for texts between Ms. Reed and Ms. Voss. And we do have texts. They are, the manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can sort of guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I'd ask that we're willing to turn those over. They were not off the record. But I ask that we be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay.
And that's all I have.
All right.
Also, interesting point that this lawyer makes, is that if Gretchen Voss's notes come in, because it's her perception often, he says, and her recollection that she could become a witness in this case. And I would be surprised if Gretchen Voss weren't a witness in this case. That Boston Magazine article set the narrative of the case that has kept on ever since, that no one strayed from. And it's largely Karen Reed's narrative. It's the defense narrative. Karen Reed went and slept that night. Do we know? How do we know what Karen did? Well, we know she slept because she wasn't making phone calls. How do we know she wasn't on the internet or doing something else? We don't know. No mention of the plumber. No mention of that in Gretchen Voss's story. Hey, I'm just waiting at 8:30 o'clock on a Friday night for the plumber to come by. And he says, to finish fixing my plumbing, my hot water issue that John O'Keefe's father could have come fixed for free. Karen Reed suddenly had to seemingly make him jealous with it. It delayed her. It delayed Karen Reed from getting to the bar to meet them all. What would be the first thing that John O'Keefe would say to Karen Reed? How'd you get on with that plumber? I want to see these communications with this plumber. Do they exist on Karen Reed's phone? Was there a Richie the plumber? Was this an issue, or was this something she was fishing out to make John O'Keefe jealous with? My hunch, if I had to guess, would be the latter. But nobody talks about it because it's not in the Boston Magazine article, so it's not important. But it's right there in the evidence.
Thank you very much. Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan?
I have a copy here.
Okay. So what I'm going to ask you to respond to is on page 5. First full paragraph. The paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
Look how fast these lawyers read this stuff, right? So he's going to answer why it wouldn't be important that if Karen Reed got caught in inconsistencies with Gretchen Voss. There's Paul
This
O'Keefe.
posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio.
There's Paul O'Keefe in the back, John O'Keefe's brother.
Because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains many damaging admissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews the story changes. But at one point she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the Commonwealth's position. That is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made. 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Miss Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally, in Miss Voss's interview, as I mentioned, there are statements, redaction, a return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water.
Very interesting. This is something that Innocence Fraud Watch has brought up in her blog, that Karen Reed said, wait, I was sipping water. I didn't really drink. I was just there to hang out at the waterfall. Then she says that he went to the front of the house, then the side of the house, switching that around. He calls some of these confessions. Very strong language in this interview. And Karen Reed came out, you saw the clip yesterday, and said, well, if you hid my confessions, then this is all malfeasance by the press. But we know the press does hide these kind of statements to further an innocence fraud narrative for whatever reason, whether it's a more salacious story, the wrongfully accused woman up against the corrupt big government, or for their own personal prejudices, and to further a narrative that there's so many wrongfully accused and wrongfully arrested people. But they know that the big story is not rightfully arrested, rightfully accused woman, guilty woman facing the state. They know that the public loves this story. This is the kind of story that gets you the big awards, the big promotions, especially in very blue Massachusetts. So there's a reason why the first Gretchen Voss piece was Karen Reed's story and not the story of John O'Keefe. And I understand that John O'Keefe's family did not cooperate with that story, but you could still have asked his friends. You still could have made a different narrative. But as we know, Gretchen Voss, I think, knows a lot. And if she gets called to the stand, it will be, I believe, extremely informative. And we'll hear a lot of things we've never heard before. And I would expect her to be called to the stand if this evidence gets in. Be shocked if she wouldn't. And they'll probably call her early so that she can report on the rest of the trial. She may be one of the early witnesses in the case. If that happens, or it may just be her evidence, but I would be shocked. He looks like he's Hank Brennan, this new specially appointed prosecutor, is coming for everything. He's taken no mercy, holding no prisoners, etc. If you just tuned in, started a little earlier because I have to catch a train today for the holidays. We're going over Karen Reed's hearing yesterday, where they're asking to bring in certain pieces of evidence, the Commonwealth is, and the state is trying to keep this evidence out. This is Hank Brennan, the special appointed prosecutor, once defended Whitey Bulger, once was a prosecutor himself. In fine form. and looks like he has a very good relationship with Judge Cannone. She shows him all the respect that she didn't show Adam Lally in these hearings before. And I would think that Adam Lally would feel relieved. He seems relieved. He does not seem like someone who likes the spotlight, enjoys public speaking. Very different than most lawyers that really love to get up there and make their argument. So I think he's in a role that he enjoys, that he finds more enjoyable, especially in this case where you're such a lightning rod. But very curious, I have not seen the Karen Reed supporters really go after Brennan the way they went after Lally, but let's see.
And so I think that the claim in this motion really has no relevance to the analysis. It's not on point. The reason I said there was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof. In representing the people of this Commonwealth, I am pursuing the full force of our proof in every aspect because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, the defense attorney, the defendant, and Ms. Voss could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it, none.
All right, thank you.
Wow, he's like, just because they chose not to use incriminating, just because Gretchen Voss chose not to use incriminating statements does not mean we're not entitled to. And he keeps saying that we are entitled to this evidence. We're representing the people of this Commonwealth, and we will prove our case. And I think he's bringing to mind the burden of proof, which they have the highest burden, which is beyond, they have to prove their case beyond a reasonable doubt. So he's bringing that to his argument. So if evidence exists, we're entitled to it to prove our case. We have a high burden, the highest burden in our criminal justice system.
So I know, Ms. Little, I asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add? No, Your Honor. Okay. All right, so that is taken under advisement. And now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance on all 3 or arguing all 3. But so, Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all 3. But do you have different arguments, a little bit different on each?
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the three? There are three motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10 Boston. Okay, thank you. And again, on these, Ms. Little, you don't expect to argue? No, Your Honor. Okay. If you do change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will hear you. Why don't we start with the FXT TV, Boston 25. It's paper number 400.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have...
Okay, did you guys catch that? So Hank Brennan misspoke, and Karen Reed's turning around, does a double take, and then turns around like to her supporters, like, "Can you believe this clown?" I found this amazing that she was allowed to act out like this. At the NXIVM trial, one journalist got thrown out for giving a look in the gallery. She's the defendant, and she's turning around and mocking silently the prosecutor. You guys checking this out? Let's see if I can go back just a tiny touch for this so we can watch it again.
NBC 10 Boston. Okay, thank you. And again, on these, Ms. Little, you don't expect to argue? No, Your Honor. Okay. If you do change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will hear you. Why don't we start with the FXT TV, Boston 25. It's paper number 400.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean?
And now she's the petulant schoolgirl sitting there, almost like she's bored. It's so annoying to have to sit at her own hearing. Eddie seems to be looking at the ceiling. Very immature behavior. There's one time in the trial where she really went after Alan Jackson, which should have given us a clue that they were close enough that she went out, like, how do I say it? Was whispering very aggressively at him. And then the jury came in and she straightened up. She was always looking at the jury, trying to suss them out, how they were going. But this stuff, I'm surprised it's allowed to go on. It just really depends on the judge, how lenient the judge is going to be. Some judges see everything. Judge Canoni may have missed it, may have not thought it or seen it, may have not thought of it was remarkable. But already she's got an attitude towards the special prosecutor. And if she thinks that she has got him pegged as someone who's going to make mistakes that are going to get her case overturned, maybe that's what she's making note of. Hey, like if he's leaving off an S here, he's misspeaking, maybe we can get him. Maybe we can get him in our court case in trial, in the second trial, he says something that's, argue something, say that's untrue or was not in evidence just by misspeaking. I don't know. Let me know what you guys think. Heisenberg, nice to see you. What her father said on camera, as I mentioned yesterday, is going to give Karen big problems. Correct, Heisenberg. So Heisenberg made an awesome comment, was that yesterday? It had to be yesterday, that she felt she hit something, which is an experiential memory, if you take it literally and not figuratively. She felt, so like when you hit something, you literally feel it. She told her father she felt she hit something, which meaning she knew she hit something, but she never checked. Although, strangely, Jennifer McCabe and Carrie Roberts said that Karen Reed showed them her taillight and how broken it was. Her supporters know this trial is going to be different. I think they do. And very few people were there to support her because of this big bust that happened where she invited Melanie Little and the Glairer, Turtle Boy, all her big name supporters that Tom CPU who are bringing in the big money, supporting her. And she didn't invite the smaller money people that are there every day at court cheering her on, really on the ground people. And a lot of them have walked away from the Free Karen Reed movement because of it. Thanks, Maui Swift. It's very generous of you to give 5 memberships and 5 more memberships. Thank you, Maui. Very generous. So those will be handed out at random to those in the chat. Happy Thanksgiving. Curious what you guys think of this behavior in court.
This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone. That phone conversation is before Karen Reed is admitted to the hospital. And so it is, by inference, in the back of a police car at the scene. Now, there's some ambiguity during your first discussions. The operative word, as I see it, is first. It is a particularly remarkable statement to make that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit supposedly now another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that would be the subject matter. It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life.
Exactly. So given the context, if it really was at the hospital or even before. I think I hit something. She wants to tell her father about love tapping John O'Keefe's car that caused no damage. That's what Elizabeth Little, made the argument earlier in the hearing, that of course she told her father she felt she hit something. That was when the 5:08 time when she was caught on the Ring camera hitting the car. Apparently, she told her cousin she didn't even remember doing that, which is so absurd to even believe that she would forget that as she's making the most important evidence for herself. Well, I got to say that I did this somehow. Let me do it now. Because you can see her looking at her infotainment system, which is beeping at her as she's backing up and pushing something, which is perhaps turning it down. I don't know. I don't know exactly how those things work. I know hers, according to Maestro, my mod, thank you, Maestro, that her infotainment system did not have, and her Lexus did not have, the automatic braking when you're about to hit something. But it did have flashing and beeping, and that would have gotten louder and more insistent each time, as closer and closer she got. She could not have missed that. Couldn't have missed it. I don't care how loud her music is. That's something she's adding, thanks to one of your comments, apparently to her story, that her music was very loud. Because there's the flashing and there's the beeping. And it's your car. Anyone who's driven knows that you're very familiar with how your car is and works, and every part of it. When it's that camera, they could not have missed it. Hey, G5, thanks for gifting a subscription. Appreciate it. Hey, Jill D, nice to see you. Thanks, Roberta. I love your coverage of this case. Thank you. I also laugh out loud at least once, usually more entertaining and brilliant. Thank you so much, Jill. So glad I can make anyone laugh. Back to Hank Brennan and his argument here. I think making a good argument.
And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter. And during that airing, it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all of his statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context. Some of the doctrine of completeness. We should know what the entirety of the conversation, the interview was, so that we can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial. He will be asked about this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth or anybody who would be questioning him would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or corroboration, that both sides are aware and know of the substance of that material. And that is the reason we request the pleading in number 400 for the Fox 25 footage that was not aired.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in an email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay.
My short interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. If Your Honor would allow me to start with NBC, because I think we can streamline that. NBC 10 has agreed to give promo materials in their possession. I've not only spoke to Mr. Albano, but I've spoke to the attorney for the subsidiaries that we also had subpoenaed. And they told me that as subsidiaries, they do not have possession of the materials of the parent company. And I received letters from the attorneys stating as much. So as it pertains to NBC 10, the position is that one of the subsidiaries is going to send us promotional materials. And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand, mail, UPS to a number of subsidiaries. I don't think we're satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment. It's I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10? Here, just, you know what, Jimmy, you can give it to me after. I don't have that paper number or the other one. All right, so do you want to...
427, Your Honor.
What is 427?
427.
All right, so do you want to move on to CVB TV?
Yes.
Okay.
WCVB TV has been served, and they've notified that they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so I no longer am asking WCVB TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So our position relative to the ABC materials is that ABC has been properly...
So it's really interesting that NBC 10 says they're subsidiary. They don't have the original interviews. And that it seems like this is going to be a chase. He said we could get a tiny promo that they have, but they don't have the original interviews, which is interesting. So who owns them? And they're going to have to get some really big, some research to run down who owns all these interviews. Heisenberg, nice to see you. Even in the driveway footage of Karen backing out, she didn't even step out of her vehicle there either. Before 5 a.m., she knew she hit something twice. Yeah, I wouldn't even call it hitting. I wouldn't even call that second thing hitting anything. Bumping, maybe. But, I mean, it's ridiculous to say that you're going to tell your father about that at the hospital when your boyfriend of 2 years is hanging on to life or being worked on or whatever, you know. They're trying their best to save his life, and he's already passed, my understanding. But, I mean, that's what you're going to talk about? Bumping his car in the driveway? Come on. It was absurd when Elizabeth Little. Elizabeth Little. I can just see Karen Reed turning around now at my misspeaking with her hair. Oh, Roberta, so incompetent. When Elizabeth Little made that argument, it just sounded absurd.
Served locally. Unlike NBC, that did not have a local registered agent that we could find, or perhaps does not have one, ABC does. ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know. But they have roots in Massachusetts in that they do business here. They have a local registered agent. And the reason to have a registered agent is to accept service, provide notice in case there's objections, and to provide materials. It is done routinely in civil cases when a registered agent is notified. They are then obligated to get materials even if the REM exists in a different place. Their position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being in another jurisdiction is not in the control or purview of the local registered agent would just be enacting a shell game where local or companies could pick jurisdictions they find most favorable, do business in outside jurisdictions, and avoid the consequences of that. That, I don't believe, is how the law is set up. As a registered agent, they are the same as the company. They just have a local contact to accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the registered agent, and therefore whatever materials exist, regardless if they're in Massachusetts or in New York, they are required to obtain them and they're required to produce them.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity to read that.
Okay.
Under that fifth paragraph. Do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you the example of not knowing which door she supposedly saw John Keefe go into. There is differences in her stories and versions about where she was that night after she left the O'Keefe house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so the episode that is aired on 2020 in Nightline, you hear oftentimes the author of the story, not even the interview, the author saying, and we spoke to the person, and then this is what happened, and then they go to a clip of an actual interview. The summary by the author is not admissible. It can't be used substantively. It can't be used to impeach Ms. Reed should she testify. It is hearsay. It's inadmissible. And so these summaries have a genesis somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions. And so that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements, not similar to or dissimilar to Ms. Voss interviewing here. Those are statements of a defendant which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect it. We should have the opportunity to review all of the statements and also put the ones in context that were broadcast to the nation. And that's the substance of why we want it. I'll have to take a moment to look at the response.
Okay.
So again, bringing up her contradictory statements. If you remember back to my interview with Tom Murtati, who's coming back on in December, which is close, just around the corner. We're almost there. He said, if she were my client, and now he's a civil lawyer, but if she were my client, my criminal client, I would tell her to keep her mouth shut, do no interviews. That would be the first thing I would tell her. But Karen Read went a different way. She went the Facebook stalking, get her own evidence, harass the witnesses, create an innocence fraud campaign route. That was her defense. So the point was to get this case dismissed before it ever came to trial. So she never thought that these would be brought up at trial because she thought her innocence fraud campaign, or she hoped it would be so successful that she would never have to go to trial, that the state would be so intimidated, that the witnesses would be so intimidated, no one would testify against her, and the state would fold under the pressure of all her supporters. And it almost worked. I mean, you could have gone with a different staff, with a different person at the head. Could have worked. In another state, it could have worked. I've seen, go back to my Johnny Lee Gates, it's a guest interview that was done on my channel. There's a time a prosecutor, it's a post-conviction release of a guy who should never gotten out. Prosecutor just rolled. If my girlfriend, okay, so No Strays, ENT says, if my girlfriend drops me off at a house party and the next day he's found outside unalive, the first thing she'd say is, he was in there, not I hit him. Exactly. Great point. Great point. Oh, he went in there. I know he went in there. Not, this is my fault. That is really damning. Sometimes lawyers don't even like you to apologize because you're taking the blame for something, right? Apologize in a civil case or otherwise. So this is not good. Again, her own statements were the thing that really made such a big impression on me. One of the many things in the first trial. All the witnesses with consistent statements that were all so consistent. I hit him. I hit him. Is he dead? I hit him. This is my fault. I hit him. Or she's taking responsibility. Left a deep impression.
Mr. Albano, we'll give him a couple of minutes just to read it. Sure. Paul, do you want me to step off or stay here? We'll stay here.
May I?
Sure.
Thank you. Your Honor, our position is we disagree with that proposition. We are not trying to subpoena another state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this to New York. There is a reporter's privilege in New York that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have an entitlement to subpoena them here, and we follow Massachusetts law. There are a couple of cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and shepherdize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it. But not.
I'll give you that opportunity, but I will hear from Mr. Albano today since he's here.
Of course. But our position is, although they would like us to go to New York, we can subpoena in Massachusetts to the registered agent, and that entitles us to the material. So that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albano.
Thank you, Your Honor. The two cases I cited, just to be clear, they address the Uniform Act, which Your Honor dealt with last year. They don't address the specific issue the Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe the service issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now, the analogous areas I thought of was, okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them through their registered agent, but that wouldn't change the domicile or citizenship of ABC. If there were a diverse plaintiff and a diverse defendant, it would still be removable. It doesn't make them residents of Massachusetts, or, for example, subject to taxes in Massachusetts. It's simply a way to make service of process, but the plain language of the Uniform Act and the policy underlying it is not overridden by service. The two cases that I did cite, one is the grand jury case out of I think it started in Rhode Island, SJC case, and that just generally explains how this Uniform Act works. You go to the Superior Court here, you get an order, you travel to New York, and New York decides whether the subpoena will issue. The second case, which I think was in re contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues an order under the Uniform Act, Commonwealth travels to New York, the New York court then decides, does it enforce it, or does the privilege that exists in New York
So they're arguing about whether they should subpoena ABC in New York, or they have the jurisdiction. They have to go to New York, be in New York to subpoena them, I think. That they can't subpoena them from Massachusetts to testify. It going into some heavy case law. Heisenberg says, one last thing, Roberta. She mentioned about being the only one trying to save his life. Wasn't that arrogant and ridiculous? Cue how many first responders testified last trial? When clearly someone else was helping as well. I don't think she helped at all. She didn't clear the snow off of his face. She got on top of him and straddled him and lifted up his shirt and lifted up her shirt. I mean, I got in trouble with YouTube last time I said what it was, but it reminds me of very dark things. Let's put it that way. And I don't think she never tried to clear his airways I don't think she ever did mouth to mouth. I think this was a performance to show she was hysterical and she just felt she had to do something. But Jen McCabe called 911, not Karen Reed. So I think she was, if anything, a hindrance, which is what you hear with the first responders. That she was not helping and that she was, in fact, like psychopaths, or as you all know, all psychopaths are also narcissists. She needed to be the center of attention even after John O'Keefe passed and needed life-saving measures, possibly. I think he was beyond being saved at that point. I think we are all in agreement of that. But they didn't know that. Or maybe they did. I think they all did know that. I think Karen knew that. But these people had a job to do. She was being disruptive, unhelpful, needed to be the center of attention. And I just find her actions so deeply disturbing that day. Straddling him, lifting up her shirt and his shirt before ever uncovering his airwaves. Hello?
Is that privilege dispositive? And that's what we say is the right answer here, that, yeah, they have a point, they can make service, but it doesn't override the statutory requirements of the Uniform Act. And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out, fine, we'll get you copies, and that's what I've been told by the client as well. WFXT, which unlike ABC is here, does have some raw footage. The station's position is that if Your Honor decides under the Rule 17 standard that yes, this footage is relevant enough to come within the Rule 17 scope, then WFXT will produce that information. I do expect it will already be published before, so the unpublished I do expect won't be unpublished anymore, so they'll probably be in a position where they're simply turning over published information, not unpublished information. But I do think that, so I think WBTS and WFXT are effectively resolved.
Okay. Do you want to respond, Mr. Brennan? Thank you, Mr. Albino.
I'd just like to give one example that I'm sure you've thought of, and we see it often in tort law. If U-Haul is a foreign company, I don't know where it's located, but if the principal place of business is in Texas, and there's an accident here in Massachusetts, and I'm requesting as part of my litigation corporate materials, I do not have to follow the Uniform Act to go to Texas or litigate in Texas under Texas law. Because the company operates also in Massachusetts, as does ABC. I can sue in Massachusetts, and that company, this registered agent, is obligated to get those materials for me. Otherwise, a company could simply hide in whatever state is most beneficial to them, make it impossible to litigate or obtain materials, and there would be subterfuge throughout the entire process. We have jurisdiction here because they operate here, because they have a registered agent here. It does not matter where their corporate or their headquarters is. Thank you.
All right, any follow-up, Mr. Albino? Yeah, sure.
My first point is that we're dealing with a statute here, and the statute says this is how it works when you have an out-of-state witness. in a criminal case. So that's different than civil discovery. The second thing I'd say is ABC has a registered agent here, but WCVB is owned and operated by Hearst Corporation. Hearst Corporation is totally separate from ABC. That's why neither of them could produce the documents in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, Hearst, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC News programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the grand jury case, the first case I cited, that the same procedures apply for documents as for witnesses.
Okay.
Thank you.
All right. Thank you. So those are all the Rule 17 motions we have.
So I'd be curious to see what Brennan's response is to that. So you have to be in the same state to get documents from a company? Or do you have to go to New York with New York lawyers representing? I don't even know. It's blowing my mind. Maybe I have to go back and listen one more time. But this is pretty much the end of it. I mean, the end of the hearing. I know there's more, but I think this is the end of the arguments. Judge Cannoni still has not decided whether she is going to move the trial or not. As is, it's still set for January. I think she's going to move it. Both parties, both the Commonwealth and the defense, want to move it. I think I would be surprised if she said, no, we're going in January. And I'm very curious if the defense is going to make the same last-minute argument to move the trial to a tiny courtroom. It would be great if more people could actually attend this trial. I always think they're going to say that the juror seating is not sufficient enough in this courtroom, because everything was difficult about that trial. Technically, to film it, the hearing was really hard. It was just felt tiny and small, and like not enough room for just the size of the trial in general. But we'll see what she does with that. Quickly, let me get to your comments. I'm just going to, before I skate out, no music tonight. No time for music. Go right into your comments. Cuddles and Yum says her father's cell records likely show him crazily calling lawyers and bail bondsmen immediately after his daughter's call. Right? I mean, I think they're very much alike, Karen Reed and her father. They seem cut from the same cloth, both into finance. Her father is finance professor. She followed him as a assistant professor at Bentley College. Or is it Bentley University or Bentley University? Is it Bentley College or Bentley University? Excuse me. Joseph Kane, 6213, says, I am curious, Roberta, when you realize you have been played by the corrupt Massachusetts State Police and McAlbert's, a.k.a. Food Stamps, a.k.a. Kate Peter Brigade, will you just stop posting vids or apologize? False innocence narrative, asking for a friend. Well, if some kind of incredible evidence came in that made sense out of all the evidence in this case that implicated someone else, of course, I would change my opinion. But I wasn't convinced by Kate Peter or I was convinced by the evidence in the early filings, Karen Reed's own words, Karen Reed's own actions. I found it very strange for an innocent person to be, at the time, I didn't know she was behind it, but I thought it was very odd that she never called off the dogs on this witness harassment campaign, that she'd want her name affiliated with it. I didn't know she was behind it. I thought that was very odd for an innocent person to want other people treated this way. Could mean she's just a horrible person, but it just seemed to me that it was somehow useful to her and she needed it. And if you need it, an innocent person doesn't need a witness harassment campaign. Bunny Buchanan, that is before the trial, and I was just examining what was in the public domain. Gretchen Voss is such a hypocrite, says Bunny Buchanan. Files affidavit out of fear of intimidation. Say what? Wasn't Voss in attendance at rolling rally at Jen McCabe's home? Yes, she was in attendance at the rolling rally. Blacklisted 4885 investigators sometimes employ a filter team or taint team. So I brought this up yesterday. I'd never heard the expression taint team. Brennan brought it up, and in relation to Karen Reed's phone, he was saying that it went to a taint team when material was extracted from her phone, and he felt that maybe what he got could possibly be incomplete. Thought that was interesting. Composed of individuals not involved in an investigation to prevent investigators from seeing information that could taint evidence, such as information prosecuted by attorney-client privilege, and no doubt this process can be abused by the unscrupulous. Interesting. Thank you very much. I pinned that to the top of the comments, so I thought it was so helpful. I really appreciate you, Blacklisted, for knowing that. I didn't know that. I've never come across that term before, and I didn't even know that existed. So very interesting. Very interesting. Always so much more to learn about our justice system. So I am going to catch a train, guys. I'm off tomorrow. I would think I'm off tomorrow. But I will see you as soon as I can get back and get back into the swing of things. I may be off Friday. I'm not sure yet. Oh, I'm off Friday anyway, but I may do a special show Friday. I'm not sure what I can manage. But I will definitely be off tomorrow, I think. Definitely off tomorrow at 6 for sure. So have a great Thanksgiving, everyone. So glad you all could hang out with me and listen to most of the rest of the hearing with me. We still didn't make it all the way through, but you heard most of what I found was the really fascinating stuff of the hearing. So have a terrific night, everybody, and a great Thanksgiving. I'll see you soon.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet. John, you were my mark. My innocence from